We're taking New York to the Supreme Court over their mistakenly named Concealed Carry Improvement Act, or CCIA in our case, Antonyuk versus Negrelli. Stay tuned and I'll break down our petition. Hi, I'm Ben, and you're watching the Minuteman Moment. Before we get into the video, please like, share, and subscribe to help us fight against YouTube's algorithm. Now, the Concealed Carry Improvement Act represents New York's blatant refusal to comply with the mandate set forth in the landmark case New York State Rifle Pistol Association versus Bruen in 2022. A quick refresher for everyone. Bruen overturned New York May issue licensing scheme for concealed carry permits. Unfortunately for New York gun owners, the CCIA system that replaced the May issue scheme is somehow even worse and more restrictive. That's because the Concealed Carry Improvement Act is an attempt to nullify the Bruen decision. These same anti-gun politicians decided that if New York must issue concealed carry licenses to ordinary citizens after Bruen, they would do whatever they could to discourage applicants. They did this by imposing ridiculous licensing requirements and then rendered any remaining licenses effectively void by prohibiting carry virtually everywhere in the state through declaring a multitude of brand new, sensitive locations. Now, GOA sued over these restrictions and won at the district level. However, the Second Circuit Court of Appeals was eager to intervene on behalf of New York's anti-gun politicians. In our case, New York has almost relied entirely on a few outlier laws from the late 19th century as justification for their new restrictions. These laws that New York used as examples were created to disarm minority communities during Reconstruction and after the Civil War. In their ruling, the Second Circuit ended upholding most of New York's laws. And while GOA did manage to quash a few of the laws, some of the most egregious sections remain intact, including the good moral character requirement. The good moral character requirement of the CCIA stands in direct opposition to the Supreme Court's clear rejection of discretionary suitability determinations in the Bruen case. So why would the Second Circuit uphold so much of a law that directly defies the Supreme Court? Well, the answer may lie in a law review article that was cited in the Second Circuit's decision. In the article titled "The Dead Hand of a Silent Past: Bruen, Gun Rights, and the Shackles of History," the author refers to the Bruen decision as unsatisfying and lays out a playbook for judicial responses to the law. Additionally, lower courts are encouraged to engage in the time-honored practice of narrowing Supreme Court precedent from below. It's clear the Second Circuit means to defy the Supreme Court's ruling in Bruen, but the consequences of this ruling could be wide-reaching if not taken up by the High Court. If lower courts ignore case law set by the Supreme Court, the consequences for any law or ruling could change based on the political alignment of the jurisdiction. It would be anarchy. This is why GOA is petitioning the Supreme Court to take up our case and answer the following questions. 1. Whether the proper historical time period for ascertaining the Second Amendment's original meaning is 1791 rather than 1868. And 2. Whether the people must convince government officials of their good moral character before exercising their Second Amendment right to bear arms in public. Gun Owners of America's Senior Vice President Eric Pratt had this to say: New York politicians just couldn't help themselves when they quickly doubled down with their unconstitutional edicts following the Bruen decision. I'm incredibly confident the justices will take an extra close look at this case, since their previous ruling was ignored by the insubordinate tyrants in Albany. We're excited about the opportunity to serve Kathy Hochul and her cabal another plate of humble pie if the court takes this case. Sam Paredes, on behalf of the Board of Directors for Gun Owners Foundation, added, "We sent the warning out to politicians far and wide following Bruen. Fall in line or we will make you." Sadly, New York refused to honor the Constitution, so we have no choice but to follow through on our threat. We urge the court to take the case and once again rebuke New York's unconstitutional gun control. The Supreme Court must clarify these questions in the wake of the Bruen decision and set the record straight for lower courts across the country. Thanks for watching. Be sure to check out our other social media to stay up to date with GOA's latest fights for your rights.